Hello and welcome to Legal Briefs, and right away I'm giving you a disclaimer. Today I'm going to tell you how to get a lawyer to take your case, and that includes potentially lying to the lawyer. You will not hear this information anywhere else, and I feel no qualms about telling you because other lawyers lie to me every day. So here we go. I'm about to tell you some secrets. By continuing to watch this video, you hereby agree to never use this information against me or my law firm. In preparing for this vlog, I did some research which basically consisted of me Googling how to get a lawyer to take your case. And what I read was essentially mostly gobbledygook. As a brief aside, gobbledygook was a word created by a Texas congressman in 1944 to mean meaningless political talk because the sound of politicians talking reminded him of the sounds of turkeys. In doing research, most of the articles I read consisted mainly of advice like be prepared and organized, bring your evidence folders, dress professionally, listen to what the lawyer says and ask you. Probably some guy at a state bar office drafted an article back in 2001 and has been copied and pasted 1,000 times since then by first-year associates tasked with updating the firm blog. In any case, the articles you're going to find out there on this topic leave out the lawyer's incentive. What does the lawyer want? What's on her mind? And without knowing the lawyer's incentives, you cannot properly prepare to speak with a lawyer about your case and maximize the chance that she will take it. So the real question is, what's on the lawyer's mind when you first meet with them? A lawyer is motivated in general by 4 things. Money, 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 money. I'm just kidding. First is money. The second are headaches. The third is time. And the fourth is heart. So first let's talk about money. Probably the first thing on a lawyer's mind when she meets with you is, how will she make money on your case? There are basically 3 ways lawyers get paid. There's a flat fee, an hourly fee, or a contingency fee. If the client is paying, it's fairly straightforward. If you can pay a lawyer $300 an hour, the lawyer will be your magic genie. I mean, before you even pick up the phone to call for a status update, you will magically receive a phone call from your attorney and a follow-up letter, and then a follow-up email to the follow-up letter, and then you will receive the magical bill with lots of zeros in it. But that's probably not why you are here. You are here because you want a lawyer to take your case on a contingency where they take a percentage if they recover money for you, and if they don't, then they don't get paid. So there are 2 things lawyers think about when they're thinking about contingency cases. One, will we win the case? That's obvious. But also, and more important, will we be able to collect any money from the defendant if we win? In the personal injury tort world I live in, we often have to let a case go because the driver has no insurance. It sucks, it's not fair, but the truth is that collecting a judgment against John Smith and the 2010 Hyundai Elantra is probably a 1 in a million shot. There's just no money there. So in that situation, what can you do to increase your chances when meeting with the first time with the lawyer? First, be ready to tell the lawyer when she asks you what your damages are. I often meet with people who haven't thought that far ahead and can't answer the damages question, which is literally the money question. For example, someone rear-ended you and you are not injured, but want to make a claim against them for the damage to your car to get it fixed. When you meet with me, you show me a picture of your car and it doesn't look that bad. I think, okay, that's a bumper, maybe 1 or 2 additional panels, maybe $1,000, $1,500 to get it fixed. I'm not going to spend 4 or 5 hours to get 30% of $1,000. It just doesn't make any sense for me. So you have to come prepared and you have to say, listen, silly lawyer, this is not just bumper damage. The accident bent the frame. You can't see that on the picture. I took the car to my cousin Vinny's auto repair shop and he gave me a $5,000, $6,000 estimate for bodywork and to straighten the frame. And now we're talking. I mean, the lawyer can make about $1,500, the client gets $3,500. That is potentially a feasible case. But you, the potential client, have to think past to the will I win and present the how much money can we win. And the second thing to be ready to talk about is collectibility. I spoke with a client last year and I went through my talk with them about how a judgment is just a piece of paper and we have to be able to collect on the judgment. And the client had actually thought that through, which I gave her props for. And she showed me some pictures on Facebook of the tortfeasor in which, first of all, it looked like a complete jerk. And secondly, he was showing off his Mercedes, his bling bling, and maybe he was a guy with some money. So yes, I ended up suing T-Pain. No, just kidding. T-Pain actually seems like a really nice guy. It wasn't him, but the pictures were enough to get me interested in the case, and I took it. Just don't ask me how it went because apparently all the bling bling was fake and the Mercedes was his dad's. By the way, did you know T-Pain stands for Tallahassee Pain because he's from Tallahassee? I would never sue anyone from Tallahassee out of pity for them. Anyways, back to your case. That's the first thing. Be ready to talk about the damages of the case and collectability. That's the money part. The second part, what are called headaches. The next thing that's on a lawyer's mind when meeting with a potential client are headaches. I've been doing this long enough that I can smell a headache client from a mile away. You do not want to be seen as a headache client. There's a lawyer help book out there that I read many years ago that said a lawyer spends 50% of her time on 10% of her cases because of client problems and problem clients. The advice in the book was to get rid of 10% of those cases and you would free up 50% of your time. I never took that advice because I'm a masochist. So for purposes of this vlog, let's just assume you are a headache client. So now, how do you hide the fact that you are a difficult person and maybe even clinically insane from your lawyer? The first thing is, do not tell the lawyer you are crazy. You'll be surprised. I've received online inquiries from potential clients where the clients say in writing that he has mental issues, that he was Baker acted or was on numerous psychiatric medications. I felt like Jack Nicholson from The Shining wanted me to represent him. Now, I feel sorry for people that truly do have mental problems, but there's just no need to lead with "I am crazy," especially if it doesn't have any bearing on your case. The second thing to hide from your lawyer, am I talking about lying too much? Is that you have run your case by every other lawyer in town and were turned down. That will get me thinking, if 5 other lawyers don't want your case, what do they know that I don't? Or maybe you're just getting better at hiding your difficultness and craziness during consultations. The next thing, and often the biggest mistake I see with potential clients, do not use legal jargon when writing or speaking with a lawyer. A client who is also a wannabe lawyer is destined to be a headache. Don't say the other party committed fraud and told me that the car was in good running shape before I bought it. Just say the seller lied to me when he said the car ran well. When I see or hear legal words from potential clients, my headache radar goes off. It's like being a doctor nowadays. 90% of their headaches come from people diagnosing themselves from an article they read on Facebook. Leave out the legal jargon and let the lawyer fill in the blanks. Okay, here's a bonus question for all you amateur lawyers out there. Why didn't the guy who tells you the car runs good commit fraud? $5 for anyone who can tell me why that's not fraud. And finally, do not, I repeat, do not ever talk to a lawyer about how you sued your last lawyer for malpractice, filed a bar complaint against a lawyer in the past, or even reported a doctor to the medical board. We lawyers take our license very seriously. They cost us a lot of time and money, and they are how we support our families. Your bar complaint puts my family at risk, and I will not even consult a potential client if I know they have grieved an attorney in the past. Okay, the third thing to think about is the lawyer's time. Always show that you are respectful of the lawyer's time. Lawyers are always stressed for time. Do not send me a 5-page timeline of your work history before you got fired. Do not launch into a 30-minute play-by-play of how your boss harassed you during our first phone call. This is a warning sign to me that you are going to be the type of client who keeps me on the phone for an hour for what should be a 5-minute phone call. I have clients that call me and really I have to take a deep breath and gird myself because I know they're about to age me a year, listening to my client who watches TV all day and has nothing else to do, talk my ear off until I have to force him off the phone. And to this client I say, again for the 100th time, well, great talking to you. I'll call you back after we get a response. And then the client just keeps going and going and going and going and going. So don't be that guy, because honestly, I wish I could go back in time and never pick up that first phone call from him. Yes, I'm willing to risk a time warp disaster in order to have never taken that case. So don't be him. So now we've talked about money, headaches, time. The last thing is heart. Despite what you might hear, lawyers have hearts. I mean, some are dark, small, shriveled masses, but they still have them. And most lawyers want to feel good about what they're doing. So you need to present your case to the lawyer in a way that shows that you are on the right side of the moral fence in your case. I mean, sometimes lawyers have to sue people or businesses that are difficult to sue. I mean, one time I had to sue a church. One time I had to sue one of the nicest couples ever. I mean, it was literally Ethel and Norman from On Golden Pond that I sued, and I felt really bad about it. But if that is your case, if the defendant is going to be a very sympathetic defendant, you need to make the lawyer at least feel good, at least in knowing that you are a good person as well and that you need help. So don't go into the consultation thinking that morals don't matter to us. It does. A lot. Paint yourself as the good guy, or at least the other guy's the bad guy. So remember, to get a lawyer to take your case, be ready to talk about money. Don't be a headache client. Keep it short and to the point, and paint yourself as the good guy. This is our secret info. Use it only for good.